So this is a drop-in session for LAWS11065, and we're going to spend the time to discuss any questions you might have in relation to the assessment or any of the topics we've covered so far in constitutional law, or perhaps even other topics that we haven't covered, but are actually part of the topics being assessed in our midterm assessment. So welcome everyone, and thanks for joining me tonight. Okay, so would you have any questions? Anything you'd like to ask, discuss? So feel free to turn on your mic and shoot away.
Manjo, I posted a question on Moodle today. It's Monique. I wasn't sure whether my question sort of exceeded the limits of what you were able to answer.
Okay.
But it relates to, it's question 1 of the individual assessment, which relates to Quadson and his termination from public service.
Okay.
Now, I guess the difficulty that I have is that I work for the public service, and so I've kind of immediately moved my thinking to the Public Service Act and gone and followed the trail and done a bit of research in that sense.
Okay.
But I'm worried that I've got too off track with the essence of the question relating to constitutional law. And I guess, I guess I just wanted to ask whether it's relevant or allowable for us to refer to other acts and legislation, or whether it really isn't necessary. Thanks.
Because the thing is, when you're confronted with a legal problem in the course of an assessment, it's actually possible to examine multiple legal issues across different fields of law. So for example, the one we have about Roman Quadson in the first question for the individual midterm assessment, apart from trying to answer it from the viewpoint of constitutional law, it actually has an administrative law dimension. And perhaps there's even a contract law dimension and so on. You should veer away, you should avoid from addressing any legal issue that has nothing to do with constitutional law. So the focus really is on constitutional law. And in fact, the focus should only be on the first 5 topics covered by our unit. And so it's possible that there are also topics, other issues in constitutional law that might pertain to topics covered in weeks 6 to 11. We shouldn't even be addressing those. So the way to answer this particular question should really be to examine it only from the viewpoint of any principles and legal rules that we have examined for weeks 1 to 5. And it is definitely unnecessary to examine any statute, whether it's the Public Service Act or any other statute or regulations pertaining to an employee of a federal government agency, because that isn't really what we're trying to address. In fact, as far as this particular question is concerned, because there had been a question posed earlier as to whether it was necessary to try to examine the definition of what constitutes an inappropriate relationship, and that can be examined from an ethical point of view, or perhaps from the viewpoint of criminal law. We just assume that there is a finding that he has committed an inappropriate relationship, and it is very unnecessary to actually delve into that issue. That is not the legal issue, whether or not he committed the inappropriate relationship per se. That's not the question. The question, though, is related to that, but it's really, so if I read it now, it says he wants to know if he can challenge before a federal court the legality of his dismissal from government service on account of what he claims to be an incorrect finding of facts. So the focus is on the fact, on the 2 aspects. One is whether he can bring the matter before a federal court, emphasis on federal court as opposed to a tribunal. So, meaning in non-chapter 3 court, so can he bring the matter before a federal court to question the legality of his dismissal? So that's the other aspect. But in relation to the incorrect finding of facts. So when I speak of an incorrect finding of facts, you can actually just, oh, am I giving it away? Yeah, that's the tricky thing. So, so I'm not. I haven't really discussed anything else. I was just trying to clarify the question. So you can just actually put in any sort of facts, but let's assume that he claims that there is an incorrect finding of facts. It could be anything. But for our purpose, we're assuming that the facts relate to the inappropriate relationship. So that's the legal issue there. And that's actually covered in weeks 1 to 5. Yeah, so as Erin pointed out, yeah, it's quite tricky for me to delve into this further because I might end up giving away the answer. And I'm sure that some of you have actually already picked up on what the legal issue is. But I think I gave away some, you know. I think I kind of hinted on what the legal issue is, but I can't say anything further.
That's helped me to just steer my direction away from the tunnel I was going down. So thanks.
Yeah. And the question about not worried about evidence, so Erin has raised something here in the chat box for those who will be viewing this recording later on. That point about whether or not Quadson should be worried about evidence is actually connected to the idea about his claim that there is an incorrect finding of fact. So they kind of related to each other. But again, it's not about the evidence per se. It's really that issue about bringing the matter before a federal court concerning an alleged incorrect finding of facts. Yeah, especially for those who are probably taking up administrative law now, they will know what, you know, the legal issue here is. Whether it can be introduced or not, no, that's not the legal issue. So what we need to remember, because we do have some students who are currently taking up administrative law as well, and I know that some of the students taking up constitutional law now have also previously taken up administrative law. So for those of them who have taken up administrative law or currently taking it up, they will pick up quickly the legal issue for this legal problem. And as I said, I cannot say more because, you know, I might end up identifying the legal issue for you. Okay. Anything else?
Hi, Manjo. It's Tamara.
Hi, Tamara.
So just going off what Monique was saying there about utilising other legislation, well, not that it's outside of weeks 1 to 5, but is it sort of basically keep your answers within the information within weeks 1 to 5, whether that be the study guide or the textbook and any cases that may be within that?
Yes.
If we do sort of look into other legislation and things like that, can we at least touch on it to help us get to our conclusion as opposed to relying on that legislation, if that makes sense? Or are you just sort of saying just keep it solely to weeks 1 to 5 and the information that's in those topics?
The thing is, in answer to your question, when I formulated these legal problems, I wasn't really even considering any specific statute at present. In fact, when I cite a legislation or a statute in the 4 legal problems, all the statutes that were identified there, well, not really all, but most of them were likely to be hypothetical. They were fictitious, except perhaps for the Immigration Act, if I ever mention it. But so having said that, it really is necessary for you to examine the provisions of any particular legislation. It's really unnecessary. Stick to what the facts are there. And so in other words, so in answering a legal problem, for example, in relation to constitutional law, what is really crucial is to be able to identify what exactly is the legal issue that's involved. So when we ask, for example, what exactly is the legal issue, we're essentially, it's a shorthand question for asking what can make this particular statute or law or action of any of the branches of government unconstitutional or invalid? So that's essentially the shorthand question. So if you were to ask the question, so you would know what the legal issue is. What can potentially, make this particular statute or act of the executive, for example, invalid or unconstitutional? So that's the question. What can make it unconstitutional? And there are actually 4 ways by which a statute or an action of the parliament or even the executive can be invalidated. And they could be, 1, because they impair the partial separation of powers in Australia. 2, it could be because the subject of the legislation of the Australian Parliament is actually one to which belongs to the states exclusively and not to the Commonwealth Parliament. But that second argument is actually something that will not be covered in the midterm assessment, because that's covered only in weeks 7 to 10. The other dimension, which could be the basis for questioning the constitutionality of a statute or an executive action, would relate to the question of whether or not it would impair a constitutional right or freedom, whether expressed or implied. And again, that particular constitutional challenge is not something that is covered in the midterm assessment. Now, but the other particular argument you could raise to question the constitutionality relates to the basic or the fundamental constitutional law principles that we have discussed. And that would relate to, for example, the rule of law, representative democracy, responsible government, or constitutionalism. So, in other words, as far as the midterm assessment is concerned, so because of that, I've identified 4 possible arguments which you can raise in trying to question the constitutionality or validity of a statute passed by the Parliament or a regulation or action of the executive. I mentioned 4, but the 2 key arguments you would likely raise in the midterm assessments for the purpose of questioning the validity or constitutionality of the action of the executive or of the Parliament would relate only, 1, to the principle of separation of powers, and 2, concerning one of the fundamental principles of constitutional law, which I said was responsible government, representative democracy, constitutionalism, and rule of law, among others. So you should just limit your answers to those. Now, if therefore you end up talking about the fact that this particular law is not among those powers, is not among those subjects for which the Commonwealth Parliament can pass a law, then although that would have been a valid legal issue, it is not something that's being assessed in the midterm assessment. I've been very clear about that. You should only limit yourself to what has been covered in weeks 1 to 5. And I'm only testing. I'm actually just assessing your answers in relation to the first 5 topics. So going back to the question, so let's repeat. It's very crucial when you try to answer a legal problem for constitutional law. The shorthand, the simple question you're actually asking is, what can invalidate or what can make this particular law or executive action unconstitutional or invalid? That's the question you're asking. That's the legal issue. And then you're going to say, the legal issue is, can this law be unconstitutional for breaching the separation of powers? Can this law be unconstitutional for going against the principle of representative democracy? And of course, representative democracy is quite broad. There are some subtopics there which I can't discuss any further because it's actually part of the assessment. So representative democracy is broader so that because of the principle of representative democracy, this is the effect. And the courts will not, for example, do something. But again, I can't go into that further because that's into the assessment. So let me repeat, you always begin by trying to identify the legal issue. And as far as constitutional law in particular is concerned, the basic question is, what is it that could potentially invalidate or make this law or executive action unconstitutional? And it can be, as I said, unconstitutional on the basis of separation of powers or one of those fundamental constitutional law principles. Now, once you've done that, once you've identified the legal issue, so identifying the legal issue is crucial because the legal issue actually delimits or makes you focus on the particular relevant rules or laws that would inform the legal issue. So in other words, if the legal issue is about separation of powers, and in particular, it could be, for example, the fact that according to the Boilermaker's case, it would be invalid for the Parliament to vest non-judicial powers on a non-Chapter 3 court, assuming that that is the legal issue. Then when you state the rule, and we're following the IRAC format, so we're trying to follow the IRAC format, issue, rule, application of the rule to the fact, and the conclusion. So when you follow the IRAC format, as far as the rule is concerned, the only rule or rules you will discuss will be those that inform on the legal issue or are connected to the legal issue. So in other words, having identified that this is the legal issue, what then are the legal rules that are connected to that legal issue, so that when you apply those rules to the facts, it can make you arrive at a conclusion. So do we follow that so far? So we identify the legal issue, because the legal issue is crucial. It delimits the rules and the principles that you need to discuss. So once you've identified the legal issue, you then identify the rules, you discuss the rules, you elaborate on the rules. So that's the second aspect. And then what happens when you try to apply those rules to the facts? So application. So when you apply the rules to the facts, it leads you to conclude, therefore, that. So it naturally leads to the conclusion. It naturally leads to the conclusion. So that's essentially what we do in the IRAC format.
Sorry.
We'll begin first with, sorry, I didn't get your name. Sorry, it's not coming up. So somebody has to start speaking. It's no longer Monique. So the one on the screen. Sorry, I can't remember the names of everyone. You would be.
That's all right. Angelina.
Angelina, go ahead, Angelina.
Yeah.
Yes.
My question is really, really boring. Are you happy for us to put IRAC headings in, issue, rules, application, conclusion, or would you prefer it just to flow through?
There's no need to do that.
Okay. Yeah, that's all right. I just know every lecturer is different on that front.
Yeah. I mean, if you have a subheading or a subsection which says issue, rule, application, I mean, it's not a problem. That's not a problem. But what typically happens is that if you were to prepare a pleading and you make an argument in court, it's not often the case that you really have to say this is the legal issue. You're just trying to come up with a plausible argument. So it's up to you, but there is no need for that.
Thank you.
Mando, it's Tamara again.
Tamara, yes.
So just to sort of, I suppose, clarify and just confirm what you were saying about sort of IRAC and how to go about sort of identifying the legal issue and sort of going on from there, which, by the way, was really good. It's sort of nice notes to sort of carry on through the rest of the degree. So is it, what is it about the legal issue that makes the law, decision or action unconstitutional or valid? Yes. And then, like you say, that then limits the rules, principles to be discussed, and then, so on and so forth.
Yes.
Okay, lovely. Thank you very much.
Other questions? I'm trying to look at my wrist because I burned myself like cooking pork earlier. The pork chop just blew up like that, and it splashed me. I had to wash my clothes, and it hit my face and my arms. So that's the problem when you cook pork. Sometimes it's kind of burning my wrists. It's a good thing it didn't really burn my face a lot. I had to splash my face with extremely cold water earlier, so it was a good thing. But it was a lot. It was massive, it was like a geyser. Okay, but that's the way it is. When you cook, I suppose it happens to everyone. Yeah. Okay. Any other questions? Comments?
Well, just while no one else is speaking.
Angelina, yeah.
I just want to clarify. I feel like I'm looking at it very basic basically, I've like when one of the girls that I'm working with, her and I have kind of gone through and done the IRAC sort of system. But when we're doing that, it's not overly complex. Could we be missing something, do you think? I just like sticking within that week 1 to 5 and just doing the legal issue, the rule, and then applying it. Some of the answers don't seem to be too in-depth. So with one of the ones that we've done, we've just kind of bulked it up with a bit of extra research on the topic. But like one of them doesn't feel like it needs heaps of words.
Which one?
The question 2 for the group one, it just seems really straightforward.
Ah, is that right? Could be. Yeah. So that might be a question then. But again, it's
you throwing curveballs at us,
it's easy to come up with an answer if you know what the legal issue is. But for those who don't know the legal issue, it will take them forever. They won't even be able to identify the rule, because you can't know the rule if you don't know what the issue is. So in other words, you can't have the answer without knowing what the problem is or what the question is. So yeah, you're right. Question 2 might be quite easy, but that does require legal research, because you're going to have to justify, why you think something is the applicable rule.
Yeah, we've backed it up. We've got our evidence. It just seems, I don't know.
Yeah.
It seemed a bit easy, that's all.
Yeah. I mean, that's good to hear. But again, I wouldn't say that it's necessarily easy, because I do remember that I made a statement in one of the in constitutional law a few years back when I said that the assessment I prepared was quite easy, and actually 1 or 2 of them were offended when I made that statement, because they said, it's really difficult, and it's like, what are you saying, that we're not intelligent enough? So I don't make any comment anymore whether the question is easy or difficult. So if you find it easy, that's good. It probably means that you've nailed down what the legal issue is. Because actually, once you've nailed down the legal issue, it's then a question of doing legal research. If this is the legal issue, then, what is the law? That's simply the question, right? If this is the legal issue, what is the law? So if you don't know the legal issue, you can't know the law. But once you've identified what the legal issue is, it's easy. It's all a matter of doing legal research to find out what the law is. And once you know the law, you try to apply the law to the facts. You will know the answer. Sometimes, even when you apply the facts, the law to the facts, it's still not quite clear what the natural conclusion would be. Perhaps because the facts are different from the case law. I mean, we do have stare decisis, we do have judicial precedent, but sometimes, and that's the reason why you have lawyers, because lawyers do plead. Okay, so a lawyer can say that on the basis of the law, or on the basis of this particular case, and when you apply to the facts, then this is the proper conclusion. But and that requires an argument coming from a lawyer. So it's possible that depending on the argument, that's why there is an argument there, depending on the argument that has been raised, 2 different people can come up with different conclusions. And that's not really a problem, because that's how lawyers are meant to be, right? So for as long as you've identified the legal issue, you've identified the rules, you've properly applied the rules to the facts, the conclusion that you arrive at really all depends on the way that you've applied the facts, the law to the facts, because that's where the meat is, that's where the argument is, which is why I think the application comprises 40% of the mark, because that's the crucial part. The issue is easy, identifying the rules is kind of mechanical, looking for the law is mechanical, but applying the rules or the law to the facts, that's difficult, because that's where you're making an argument. If you apply the law to the facts, then you're saying then the law has got to be constitutional, or the law has got to be unconstitutional. That is an argument, and that is where the intellectual contribution of the student comes in, because that's where a lot of the thinking comes in. Thank you for the question. Others?
Manju, hi, this is Melinda. I'm just looking at the notes for this week's readings, and the section on dimensions of executive power. So it talks about dimensions such as police power, military power, etc. And it says that these powers may be subject to legislation or legislative control. So does that also mean that those powers can be exercised without legislation?
Oh, absolutely.
And is that then executive or prerogative power?
Yeah, so very good question, Melinda, because I think that's actually covered in the assessment. So let's begin with a statement that in Australia, executive power is given to the executive on the basis of Section 61. So the executive power is vested in the Queen and exercised by the Governor-General in Council, pertaining to the execution and maintenance of the Constitution and of the laws of the Commonwealth. So that is Section 61 of the Australian Constitution. So the Constitution itself provides express executive powers. Okay, now, having said that, what we need to remember as well is that in the UK or in New Zealand, for example, they don't have a written constitution. Which makes us wonder, so if there is no written constitution in the UK and in New Zealand, does it mean therefore that the executive do not have any executive powers? And obviously that would be absurd, right? It would be an absurd statement to make. So they have got to have powers even in the absence of written constitution. And which is why it leads us to the other point that even in the absence of the express provision of Section 61 of the Australian Constitution, the executive actually has executive powers. And these are what are known, as Belinda pointed out, these are what are known as the prerogative powers, as recognized by the common law. So in other words, as judges recognize, so through a long judicial tradition, the courts have recognized that the executive has certain powers which do not rely on the written constitution or do not rely on a delegated legislation by the parliament. So in other words, there are actually three sources of executive power. We have the Constitution in Australia, we have the common law, and thirdly, we have what is known as delegated legislation, following Dignan's case, where the High Court ruled that it is constitutional for the Australian Commonwealth Parliament to delegate lawmaking powers to the executive. So the delegation of lawmaking powers to the executive is again another source of executive powers. Now, because of that, what it essentially means is that although the executive has certain prerogative powers, which is founded on the common law, meaning a recognition by the courts, according to Roddick versus Vadalis, for example, in the federal court, the federal court was quite clear that it is possible it is within the competence of the Australian Parliament to delimit or even abrogate certain executive powers. Okay, so we're assuming that it's not the exercise of executive power is not founded on delegated legislation, because if it is founded on delegated legislation, it is obviously within the competence of the Australian Parliament to delimit the exercise of the executive powers, because they're delegating the executive powers themselves. But assuming that the exercise of the executive power is based on this prerogative or discretionary or reserved powers of the executive, the understanding still is that based on the common law, it is within the competence of the Commonwealth Parliament to delimit or even abrogate the exercise of certain prerogative powers. So it can be controlled by the Parliament, but only if the Commonwealth Parliament has expressly provided for the abrogation or even the delimitation of the exercise of executive prerogative powers. Now, if the bigger question was, so as far, for example, as the executive powers are concerned, which are reserved or prerogative, this, for example, relates to the power of the executive to enter into treaties, to enter into relations with other states, for the purpose of pardoning prisoners. It could be in relation to the power to mint coins, as recognized in the case of Cadia. It could also be in relation to the power to vest, let's say, honors to, let's say, the order of, how do you call it in Australia? The order of something. So, or the vesting of honorific titles. So these are prerogative powers which can be controlled by the Australian Parliament.
Mando, it's Tamara. Can I just step in there just to make sure I'm understanding what you're saying, if that's all right?
Yep.
So the executive has three sources of power. So it's the Constitution, statute, and common law, correct?
Yes.
Right. So the Constitution and the statute is express in sort of saying you can do this, you can't do that, etc., etc.
The Constitution is express. No. What I'm saying is the Constitution expressly provides for executive powers.
Which is Section 61.
Which is Section 61.
Okay.
The statute expressly provide for certain executive powers. It doesn't mean that you cannot imply certain executive powers, because you could.
And is that where the prerogative and discretionary reserve comes in?
They're very much connected. Yes, they're very much connected.
So that's the implied side of it. And then in terms of where the common law comes in, that's tied in with the prerogative discretionary reserve as well. And then, so that's...
When you speak of the common law actually is about the recognition by the common law of prerogative powers.
Okay. And then within that, through the legislator or whoever, the Constitution and the statute can go, well, we don't like that prerogative power that you've been given through the common law, so we're going to legislate against that.
Not the Constitution, you mean the statute.
The statute, okay.
The Commonwealth Parliament can pass a law trying to delimit the exercise of certain common law.
Okay.
The answer is yes.
Okay, I think I've got it.
Yeah, so for example, you might so there are even powers like the power to enter into contracts, the power to hire, public servants, the power to create agencies within the executive government. These are, I'm not sure if this is considered a fourth dimension of executive power, although it could be argued that it's actually part of, it doesn't really matter. It could be argued that it's part of Section 61, because obviously if you vest executive power, necessarily you must imply that there must be certain other powers that would allow for the executive power to be exercised. So the power to enter into contracts, as I said, the power to hire public servants, the power to create other agencies, even in the absence of a parliamentary legislation, that would be part of Section 61, arguably. Now, whether or not that comprises a fourth source of power, I'm not even sure if that's necessary to get into, potentially, but that's definitely related to Section 61. Some might argue that it is a distinct source of power apart from Section 61, because, as we said, New Zealand and the UK do not have any written constitution, and yet the executives in these states have the power to enter into contracts or hire public servants and so on, even in the absence of a statute. So there has got to be that fourth source of executive power.
Is it also, like, say there isn't like sort of common law, like sort of cases where they've, you know, if one for a better word, authorised the prerogative powers, is it by convention as well that the prerogative powers exist?
We shouldn't use the word convention in this instance, because the concept of convention seems to have an ordinary usage, and that usually refers to the practice of the parliament in relation to the executive or in relation to the governor general, although the governor general is also part of the parliament. So we make a distinction between the common law and convention, because when you speak of convention, convention is not really law per se. It is a set of political practices that to an extent command the obedience as law, but it is not law. So it's a political practice through long usage, so that it is almost like law, although it is not really a law. The common law, on the other hand, is law. The common law is part of the legal system. And so for two reasons, we shouldn't be using the word convention to refer to, the recognition that the executive has certain reserved powers, because that is really based on the common law. That is law. Convention, as we said, is not really law of itself, and that really usually is applied in relation to the practices of the parliament.
So if it's common, I'm sorry to prattle on about it, I feel really bad.
Yeah.
So if common law can stipulate certain prerogative powers and, reserve powers, well, common law is as decided by the judiciary, is it not? In which case, doesn't the separation of powers come into that as well? Or am I barking up my
Okay, let me begin by looking at, focusing on the word you use, stipulate. I'm not sure that the common law actually stipulates. So what the common law does is actually so I don't want to use the word stipulate. What the common law does is to declare or to state what the law might be on a given set of facts. So what we need to recall is that the common law refers to decisions of the courts. So that is the common law. That's decisions of the courts through historical usage. So as far back as the 1600s, for example. And well, I don't know if we want to go historically as to the common law versus the king's courts. So that might be not necessary though. But what it essentially means is that, for example, let's assume that there is a dispute that has been lodged before a court in what we used to call the common law courts, as opposed to the king's court, where somebody would make a pleading before the king, make petitions before the king. There were common law courts, and these common law courts were actually courts which developed in the small cities and towns of England. And so in these, what happens is that even if there were a set of dispute, there was a dispute that was brought before a common law judge, and let's assume that there was no law that was passed by the king or by the UK Parliament that could have been applied to the dispute. So in other words, there is no statute, nothing from the king, because at some point the king had lawmaking powers. The rule of common law is that the judges will not refrain from settling the dispute or adjudicating on the matter. And in the process, therefore, so even with that legal gap, the role of the courts, of the common law courts, was to address the legal gap or the gap in the law, so that their statement about the law becomes the law of the land. Okay, so are we clear about that? Now, in other words, what has happened is that the common law system, therefore, in a way is judge-made, because the judges, by stating what the law is in the absence of the law, are actually making the law. Now, the other component to the common law system is that even if the judges say that this is the law in the absence of the law, or in the absence of an ambiguity in the law, it is still always within the power of the Commonwealth Parliament to change what the judges say is the law, because remember, the lawmaking powers always belong to the Parliament. Now, going back to your question, therefore, which was really valid, because you were saying, wouldn't it then be an impairment of the separation of powers if the judges make the law? So that's a really valid point, right? Because to an extent, we're saying that in the common law system, the judges make law. Wouldn't that be an impairment of the separation of powers? What we need to remember so that's a very good point, Tamara. I've never even thought about that. But what we need to remember as well is that when it comes to the separation of powers, it wasn't so much about, it has never been so much about the courts arrogating unto themselves certain political powers that, in a sense, would have weakened the parliament or the executive. That was never the problem. So it was never, except perhaps in Pakistan now, where they have the power to actually depose the current prime minister. But in the UK and in Australia, it was never a question. The tension was never about the fact that the courts seem to have become superior in the government, so that they were weakening the parliament or the executive. That has never been the issue. The issue, on the other hand, has always been that the executive and the parliament have so much power because they make the law, and they're fused because the executive is part of the parliament, that it now rests on the courts to try to control the exercise of the powers both by the parliament and by the executive. Okay, now, so was that clear? Now, there was a question from Gordon. Hang on, somebody, okay. So I suppose answer of Rin was in relation to Louise, who was asking, did everyone's sound drop out? The answer from Rin was, I think it was no. Now, I addressed a question here from Gordon. So is the common law exercising quasi-legislative power? I'm not well, you can argue, Gordon, it might be a way to say that, in a sense, the common law is exercising quasi-legislative power, but we make a distinction, because when we speak of quasi-legislative powers as a constitutional law concept, it usually has its own common meaning. And the common meaning relates to the quasi-legislative powers, usually of the executive. So when the executive, for example, comes up with legislation or bylaws and so on, so therefore they are making law, it is in that sense that we refer to it as quasi-legislative powers. Now, it can be argued that the common law or when common law judges step in to address and supply the law in the event that the law is ambiguous or the law is absent when there is a dispute, it can be argued that to an extent that's also quasi-legislative power, the exercise of quasi-legislative power. That might be correct, actually, but that's not usually the way that the exercise of quasi-legislative power is understood, because the exercise of quasi-legislative power usually is read in relation to the exercise by the executive of quasi-legislative powers. Okay, other questions? Was that clear?
Yeah, thank you very much, Manjo, for that. It's appreciated.
Other questions? So we're good. The drop-in session is actually just meant to be for 30 minutes. So unless there's any other question, we could end the session tonight. Would there be any other questions? Okay, so we're good. Thank you, Jamie Lee, and thanks everyone for joining tonight's session. I'm more than sure that the rest of your peers will be very happy for joining tonight's session and for asking questions, because your questions would have helped them a lot in understanding constitutional law and in providing answers to the midterm assessments. So thank you, everyone, and good night, and I hope to see most of you again on Thursday. Bye.